Okay, that's great. Welcome all to the Nexus Aurora Saturday Space Stream. I'm your host, Koen, of the Next Astro YouTube channel. Our guest today is Carlos Villamar of the Villamar Law Firm. And Carlos will be presenting about patenting and intellectual property rights protection. All Aerospace Innovation Network is formed on the basis of sharing knowledge. We understand that in order to advance the advent of space colonization, we will need many people and many new companies to create services and products which people will want to be using in the future for space exploration. Carlos Villamar will also be answering any of your questions which you can ask below this YouTube video or on our subreddit. Before starting, I would also like to remind you that besides asking these live questions, you can also be part of our network by clicking the Discord link beneath this video. And with that, I would like to give the word to Carlos Villamar. Thanks for being here.
First of all, thank you for letting me present to you guys. I appreciate it very, very much. I think a little background on myself may be important just to set the tone. I'm an electrical engineer. My background is digital signal processing and neural networks. I've worked in industry, I worked in industry for about 10 years before I became, as I say, before I joined the dark side and went to the legal industry and became a patent attorney. Now, I've worked at General Dynamics on missiles, so I guess technically I'm a rocket scientist in that respect. I've also worked at Hughes Aircraft on fighter aircraft, including the Advanced Tactical Fighter, which is one of the most advanced jets on Earth, I believe, right now. And I also worked on the first software-defined radio, which is a radio that can change, well, basically it could change any protocol, whether it's existing or future protocol, by changing the software. So we built the first working software-defined radio while I was at Hughes Aircraft. And, you know, a question that always gets asked is, how does an engineer end up becoming a patent attorney? Because I consider engineering the light side and I consider the legal end the dark side. Well, I was at Hughes Aircraft back in '94 when they were laying off half the company. So Hughes Aircraft was about 80,000 employees. And all of a sudden they laid off 40,000 of them. And there I was in a cubicle with 3 empty chairs. And I said, I need a plan B. And as I always tell students, I teach intellectual property law, you should always have a plan B. No matter how happy you are where you are, always have an exit strategy, whether you're a startup or whether you're at a company or whatever. So I needed an exit strategy, and I was taking a scuba course. And one of the students was a patent attorney that worked for Hughes, and I worked for Hughes as an engineer. So I asked him, I said, hey, what's a patent attorney? He said, well, you got to have an engineering degree and you got to go to law school. I said, okay, I have an engineering degree. What's law school? He said, well, it's 3 years during the day, 4 years at night. I said, okay, 3 to 4 year commitment. And then I asked him a question that's very inappropriate, especially in Europe. I asked him how much money he was making. And he was making twice as much money as I was as an engineer. I quickly did the math in my head and realized it would take me about 20 years to get to where he was financially. And that moment in time, I decided that I would become a patent attorney, and that's what I did. I've always been very decisive. My background is military. I joined the military when I was 17. And I went into the Pararescue program, which is combat paramedic, Special Forces. I went through jump school. I went through scuba school. I drowned a few times, and that ended my Special Forces career. And then I became an electrical engineer. I worked for General Dynamics doing test requirements for surface-to-surface missiles on the Aegis program, the standard missile. And then, of course, as an engineer, you want to do design, right? An engineer doing test requirements is sort of perhaps the boringest thing you can do as an engineer. No disrespect for test requirement engineers on the call. So I applied at Hughes Aircraft and I got a position there. And interestingly enough, Hughes Aircraft will not put you on design till you've done 1 year's worth of testing. So there I went right back into testing. We were testing the radar systems, the computer interfaces. It's called the flight computer for the tactical fighters. We did the F-15, the F-18, the B-2 stealth bomber. And after a year of testing other people's designs, which is the reason they understand the mistakes that engineers make before they put you on a design. And I think it's a very important concept to teach engineers other designs and the mistakes in other designs before they put them on actual design project. Well, after that, I got on the Advanced Tactical Fighter, which is the YF-22 Raptor program. And 2 years out of college, I was in charge of the flight computer, which was the dual integrated processor. It's a dual redundant computer system that takes all the radar data and converts it to the information that's needed for the pilot to do what the pilot needs to do. And 2 years out of college, I was designing the user interface module, which is the module that the pilot interfaces with in order to, use the radar and all the missile systems and components of the aircraft. And I also was in charge of the clock distribution module, which is, as you know, in hardware design, synchronizing clocks, and whether it's asynchronous or synchronous, you need very accurate engineering. And I was in charge of developing the module that did all that synchronization. So we did win the Raptor program, and at our hooray dinner, as they call it, they were telling us what a great job we did. They told us that we were getting laid off, that half of the people in the room were getting laid off. That's when I started thinking like a mercenary, which is, it's great to have company loyalty, but you have to realize that a company will fire you or lay you off based on business needs. And that's how I ended up traveling through my path to patent law, by taking that scuba course, meeting a patent attorney, and deciding that that's what I wanted to do. So at 35 years of age, I left California. I drove 3,000 miles with 2 dogs, and I moved in with my mom in order to pursue a law degree. I eventually got a job at a patent firm, and I've been practicing patent law for 2 decades now. When I got into patent law, the methodology was go get the Googles, go get the Microsofts, go get, the Motorola's as your clients. But unfortunately, unless you know high-level people at these organizations, you're not going to get that kind of work. So the only people that I was able actually to go after was the market that nobody wants. And that market is the small inventor, startup, and university market. They're the lepers of the patent community. Any large firm, when you talk about university work, small university, small inventor, they don't want that work. So my only option was to go after that market. And the way I did it was by teaching them what I know. And the way I came up with this business model is because when I got hired at my first job as a patent attorney, I did not have a law degree, but they taught me how to write patent applications. And that's when my business model was born. I said, if me, an engineer, can learn how to write patent applications, therefore I can teach other engineers how to write patent applications. And that was the beginning of my business model, which is teaching people what I know to minimize my time, because my time is the most expensive component of a patent application. If you look at a patent application, it's 10 to 20,000 euros. The government fee is 1,000 euros. So that means you're paying a patent attorney the other 19 to 20,000 euros. And my idea was, if I could teach engineers how to write patent applications to minimize my time, we could execute patent portfolios in a cost-effective manner. The title of this talk is Lean Intellectual Property Rights. And by lean, I mean, how do you do it as efficiently as possible? Lean is a concept that many startups know about. I've applied lean technology to maximizing IP portfolios while minimizing costs. Now, as a startup, you have a problem. You need money to get the patents, and you need patents to get the money. Now, I know there's a million open source people listening to this, and they're telling me that the patent system is evil, but I will tell you this. Without the patent system, there would be no Google, there would be no, there would be no major corporations, because the patent system gives you the ability to exclude others based on you can become the next Google or the next major corporation. And with that, I'll go ahead and start my presentation. I typically start with, I'm a US patent attorney, so my view is US based, but however, patents are worldwide. In other words, there's no, the focus has to be worldwide because software and hardware is applicable worldwide. So even though I'm a US patent attorney, I have many agents that I work with throughout the world to be able to execute worldwide patent portfolios. And we're going to talk about the US patent system. That's my perspective. I'm a US patent attorney. The US patent system right now is a first inventor to file system with a grace period. Now, the reason, we're going to talk about a startup OU812 down the road, which is protected open source. But part of the reason that I created this startup that we're going to talk about later is because back in 2013, the United States changed the patent laws to harmonize with Europe. Now, I was going to Europe, to Finland, to teach intellectual property law, and all the startups would tell me, we don't file patents, they're too expensive, you can get attacked before, during, and after, they're not worth it. And me being a very naive patent attorney from the United States was saying, yeah, but in America, we develop portfolios and we generate money, and they, the little startups become Googles. Well, in 2013, the US patent laws were changed based on $800 million in lobbying by the 12 richest corporations on earth, 400 million on the left, 400 million on the right, a bill signed by Obama that changed the patent laws to harmonize with Europe. And that harmonization was not a good thing for the startup culture of the United States, because now in the United States, you can get attacked before, during, and after you file your patent. Patents are super expensive, and patents majorly serve the corporations. So the things the kids were telling me in Finland actually became the law in the United States. And all of a sudden, I understood what the kids were saying, that they did not have access to the patent system. And when we switched over to the European system, it's a corporation money-centric system, which does not favor small inventor startups and universities. And what it means is whoever can run to the patent office first wins. First inventor to file, okay? That means if you're a little guy in a garage and you're inventing the next thing since sliced bread, you're competing against Google, who has an army of patent attorneys and law firms that can file patents in a second, or IBM, for example. So when they went to first to file, that favors the corporations because they have the money to file patents very quickly. In the United States, it used to be first to invent. There's a difference there. First to invent means the first person that comes up with the idea, whether they're in a garage or not, okay? So if you can prove that you were in your garage working diligently to get your patent filed, you can beat Google that actually filed their patent before you. Now I'm picking on Google, but it could be IBM, insert corporation of choice. I'm not picking specifically on Google, but I'm picking on mega corporations. So when we went to first to file, that gave the advantage to the corporations. And this is what's been happening in Europe forever, first to file. We also went to the concept of absolute novelty. In the United States, you have a 1-year grace period once you disclose your invention in order to get a patent protected. In Europe and the rest of the world, we have a concept called absolute novelty. And what that means is once you disclose your invention in a public domain, it is free for everybody. So it's open source whether you like it or not. So what that means when you go to a pitching competition, when you get invited by Google, Microsoft, or Samsung to come to their AI lab and develop innovations for them, all your disclosures are given away to the world. And that's the problem that I was trying to solve. How do we protect innovation so that innovators don't lose their technology inadvertently? So the US is the first inventor to file with a 12-month grace period after making a public disclosure. The applicant now can be the inventor, typically not the company or the university, but now under the new patent laws, the companies and universities can be applicants, which means they can get patent rights above the inventors. It's a company-centric model. The Patent Office climate right now is interesting. The US Patent Office has now done 180 degrees with Europe. It's easier for me to get software patents in Germany than it is in the United States. 10 years ago, it was the opposite. The US has become a very anti-software patent culture, and mostly based on lobbying by the major corporations, including the newer major corporations. The older corporations like IBM, Oracle, et cetera, they're for the patent system. But the newer corporations like Facebook, Google, et cetera, are actually trying to get rid of the software patents because it favors their business model, because they don't have the old patents that the older corporations have. I'll also cover some pitfalls that many startups and universities run into, including missing the boat on IP protection. That means talking about your invention before protecting it. That's a major problem that I see all over the world. Not keeping track of inventorship. Patents are based on inventorship, which means you have to keep track of who invented what and what went into the claims of a patent. And also the other problem that comes up quite often is what I call the joint venture nightmare scenario. And that's where an inventor contacts a company to help them write some software, and all of a sudden the company is filing patents on the inventor's invention. So these are some common pitfalls. Now, intellectual property is sort of like an umbrella. And when people talk about intellectual property, they typically think of patents. But actually, intellectual property is trade secrets, copyrights, trademarks, patents, and licensing. So you have to think of intellectual property as an umbrella that protects your innovation. And each part of the umbrella has different functions. Copyrights protect copying, as the term implies. So all these open source license agreements that are based on copyright are actually very limited because they only cover somebody copying the instantiation of your work. Now, what happens if you create a functional design that somebody else comes up with independently? That's where patents come in. Patents cover functionality, irrespective of the instantiation. So, for example, in a patent, you can cover a high-level concept, a process, an apparatus that does certain functions, and you don't care whether that's done with a certain programming language or with a certain source code. It's independent of that. And this is why patents are very, very important for protecting hardware and software technologies. Now, on that point, people seem to distinguish software and hardware. In my mind, there is no difference between software and hardware, and I'll explain. When I was working at Hughes Aircraft 20 years ago, the things that we were doing in hardware can now be done on your cell phone in software. Now, the fact that these processes were novel doesn't change the fact whether you do them on hardware or software. And in fact, the push to remove software patents is basically a gigantic push by the major lobbying corporations on Earth. They're spending billions of dollars lobbying our government servants to change the patent laws and to get rid of software patents, for example. But in my mind, whether you do something in software or hardware is a function of frequency. As frequency goes to infinity, the design has to become a hardware design because the computers are not fast enough to process the information. As frequency goes to zero, hardware designs can be done in software. So in my mind, there is no difference between a software invention and a hardware invention. It has to solve a problem and it has to be novel. My definition of an invention is a novel solution to a problem. And that's my one sentence description. So back to the umbrella, you have copyrights that cover copying. You have trademarks that are the brand. When you think of Google, if I ask, well, let's look at Apple. 30 years ago, if I said to you, give me your apple, you would think I wanted your fruit. Right now, if I say, give me your apple, you think I want your phone. So trademarks are the branding. That's how you create the market. The PR is through trademarks, the branding. Patents protect functionality. Licensing is how you monetize the innovations. And trade secrets is something that is often missed out. And a trade secret is something that you keep secret. Now, there's some caveats that I'm going to talk about how to protect trade secrets. But a good example that's given at the U.S. Patent Office is the Coca-Cola formula, the formula for Coca-Cola. Well, that has not been patented. Why has it not been patented? Because patents have a limited lifetime. They have right now, there's a 20-year term. Once you file for an invention, 20 years later, it's dead. It's gone. It's in the public domain. However, trade secrets last forever as long as you can keep them secret. So as soon as somebody figures out the Coca-Cola formula on their own, Coca-Cola will no longer have a trade secret. However, right now they do, and that's the reason Coca-Cola does not taste exactly like Pepsi. So now we're going to get into some of these topics. And something, whether you're open source or not, I tell people, I don't care what your IP plan is, just have an IP plan, okay? Have a plan of how you're going to handle your innovation. Your plan might be that I'm just going to give it away to the world, including Google. I have no problem with that if that's your plan. Your plan might be, I want to keep it, I want to give it away for educational and private use, and I want to monetize it to the corporations. I have no problem with that plan as long as you have a plan. Now, this is the plan. This is based on the IBM model. IBM, by the way, their corporate mission is to have more patents than any company on earth. And they do. Every year, IBM has more patents than any company on earth. I haven't checked this year, but I'll do it later. Now, I consider them the gold standard for IP protection because that's their business model. And in the IP protection plan of IBM and major corporations, it's very simple, actually. There's an idea and there's a review team. The review team is made up of business people and engineers and maybe public relations people. And the idea comes in and the team decides one of three things: patent, publish, or keep secret. That's the model. I've given you the model, whether you're Aurora Nexus or whether you're Google or whether you're a little startup. This is your model. You either patent it, you publish it, or you keep it secret. Now, why do you do these things? Well, you patent it when you want to monetize it, when you don't want other people stealing it. You want to be able to control who can use your invention. That's where you patent. When do you publish? You publish when you don't want a patent and you want to give it to the world, but you don't want somebody else to get a patent on it. See, because you can't get a patent on something that's in the public domain. So if you publish your idea, not only are you prevented from patenting it, but the whole entire world is prevented from patenting. So when I used to look at IBM and look at their tech briefs, I was like, wow, IBM is open source. They're giving away all their knowledge. No, they're only giving away the knowledge that they can't patent or they don't want to patent or doesn't have a business purpose for them to patent. And the reason they create these tech briefs is because now they create prior art. which means that 20 years later, if IBM wants to go after one of these inventions in a tech brief and somebody else has a patent on it, they'll simply say, could you please refer to tech brief number 35 of 1971 and get back to us? Because they're practicing what they already disclosed 20 years earlier. Nobody can get a patent on it. And if somebody got a patent on it, guess what? They got an invalid patent because that's prior art. So now, when do you keep things secret? Well, that's a component that's often not employed as patent attorneys. You keep things secret when you can keep them secret. And I know that sounds stupid, but basically a trade secret lasts forever as long as it can be kept secret through access control. For example, the Coca-Cola formula is kept in a safe with access to maybe 3 or 4 people in the company because they don't want the formula to get out, because once it gets out, the trade secret is no longer viable. If somebody reverse engineers the Coca-Cola formula, their trade secret is no longer valuable. So reverse engineering defeats trade secrets, but you have to keep them secret. You have to take precautions to keep them secret, like keeping them in a safe, etc. Now, this slide is sort of the concept of innovation from Hughes Aircraft. I had mentioned to you guys that I worked at Hughes Aircraft as an engineer, and actually, this was the sketch for the first software-defined radio. I was working, the way innovation works at these corporations like Hughes Aircraft is we have lunch meetings, because if they give you a free lunch, the engineers will show up. Everybody wants a free lunch, right? So they would give us these free lunches. And during these lunches, the PhDs in certain programs would present problems to the team. And this was a specific problem. Hughes had a patent on something called the digital receiver. And I'm gonna get a little technical right now. The digital receiver is the concept of having a high-speed ADD converter that can digitize a big chunk of spectrum. And now, if you can, with a very simple mixer, if you can put all the different services within that chunk of spectrum and you can digitize it, now you can technically digitally tune to every single thing that's in that spectrum. So for example, if you could sample at 100 megahertz, that means you have a 50 megahertz spectrum that you can capture. And you take AM and you mix it somewhere between 0 to 50. You take FM, you mix it somewhere between 0 to 50. You take cellular, you mix it somewhere between 0 to 50 megahertz. And now you digitize that whole entire 50 megahertz chunk. Now you have all the information within that spectrum, which means now you can digitally tune to multiple different bands using a processor. Well, the problem was that Hughes had the patent on this concept, but they didn't know how to build it because you can get a patent on something that's not yet built. And I know that sounds interesting. And that's the difference between thinking like an engineer and inventor, which I'll cover a little bit later if I remember. So Hughes had the patent on this digital receiver, but they didn't know how to build it. So here I am at lunch at the R&D group of Hughes, which is the Advanced Circuit Technology Group. These are guys from Caltech, MIT, Stanford. I call them the very, very smart people. I'm from state school. I'm from Cal Poly Pomona, Cal State Long Beach. And here I am with the geniuses. And you know, believe me, it took me some time to even apply for that lab because I questioned myself. I said, I'm not as smart as those guys. They went to MIT, Caltech, and Stanford. I'm a lowly Cal Poly guy. You know, how can I compete with these super geniuses? Well, at the time I was getting my master's in signal processing, and I was specifically studying neural networks. And at the time, I was studying a chip by Texas Instruments, which was the most advanced signal processor at the time, the TMS 3020 chip. And it was a quad-core chip, basically 4 computers, that was basically the fastest computers on Earth at that time. Now, to give you a little time frame, 800 megahertz was high-speed digital design. Hard disks were at 10 megabytes. Doom was just starting. I was playing Doom over a 2400 baud modem. So, Windows was at 2.0, I believe. So we're talking back in the caveman days. And, the processors were not fast enough to do what this digital receiver patent could do. But since I was studying neural networks, I was looking at fully interconnected processors. And since these DSPs were quad core, I was like, if I could interconnect these processors, I could have a core that has 16 cores that could either run in serial or in parallel. And I had also studied field programmable gate arrays, which is logic that can be programmed in software. It's basically a sea of gates that the software determines how the gates are laid out. So on a napkin, I literally sketched out this design, which was 4 of these quad core DSPs fully interconnected with a sea of FPGAs on the input and a sea of FPGAs on the output. And I sent that, I gave that napkin to the PhD and I said, I think with this, you could solve the problem. And much to my surprise, he said, we're going to build this. And I ended up building my own board, which was the beauty of Hughes Aircraft. I designed the board, I built the board, and we built the very first software-defined radio. And the reason is once you have a core of processors that can be run in parallel or in serial, and you have field programmable I/O, you can literally program anything, because I could program the FPGAs to do AM, FM, cellular, or space protocols in the future. And as long as you can program the output to convert that to audio, video, whatever, you have what's called a software-defined radio. At the time we built this, the term software-defined radio was actually not defined yet. Later on, I learned that actually I had built the first software-defined radio. The reason I use this example is because I was thinking like an engineer, okay? I could have gotten a patent on this architecture, but I didn't. And the reason I didn't was because I said, I just took a bunch of processors and configured them with some FPGAs. It's nothing. It's what engineers do. But I was not thinking like an inventor, because the way an inventor thinks is, has this architecture been done before at this point in time? And the answer was no. This was a unique architecture. So needless to say, we didn't get we didn't file for a patent on this architecture, but eventually it got implemented as part of the software-defined radio. Down the road, General Motors bought Hughes Aircraft, and now these chips, these became, the way this design works is first you build it at the board level, but eventually it gets put down into a chip, into an application-specific circuit. So this design eventually became an ASIC that now is part of probably many, many radios that are out there. And no patent, because I knew nothing about being a patent attorney at that point in time. So now I'm going to cover some of the concepts of patent law. I used to have a bunch of words, and then I realized that simple graphs could convey the information much simpler and in a way that engineers and technical people and even non-technical people can understand. One of the questions I always get is, when do you patent and when do you keep something secret? And it's actually fairly simple to understand. So up here is trade secret or patent, right? You either keep it secret or you patent it. And it's a function of ease of reverse engineering. As things become very, very easy to reverse engineer, but have a very, very high business value, you should be thinking about patenting. When things are very, very difficult to reverse engineer, the Coca-Cola formula, for example, you should think about keeping it a secret. Now, what's the analog for software or hardware? If you have a software invention behind a banking computer that's running an encrypted process that has anti-hack mechanisms, are you going to keep it secret or are you going to patent it? Well, you're probably going to keep it secret because it's going to be very, very hard for somebody to hack through your server and then reverse engineer the source code to determine the software that's running on this banking machine, for example. So there's a situation in software where you would keep something as a trade secret. In hardware, it's a little more difficult because you can take hardware apart. You know, if I buy your modem or whatever, there's nothing to stop me from taking it apart and figuring it out how it works, AKA hacking. So with hardware, it's a little bit more difficult, but I work with companies that have done some high-level encryption for various government agencies. And the way we get around that is by having sort of like the Mission Impossible self-destruct mechanism, where actually when somebody actually starts taking the thing apart, it actually destroys the entire circuitry. So there are ways to do it in hardware. It's a little bit more difficult. Ease of patenting versus complexity of invention. Okay. So, and this was counterintuitive for me. Simple inventions are hard to patent. Complex inventions are easy to patent. And I don't know why that was counterintuitive for me, because I was thinking maybe simple means simple, but no, simple inventions means that more people can think about it, right? If you come up with something that's simple, there's another million humans that came up with the same idea. It's who ran to the patent office first that wins in that situation. And of course, all these slides assume there's a business purpose. You know, in other words, if there's no business purpose, then you're doing it academically, and I guess that's fine, but everything assumes there's a business purpose. So a complex invention, however, is easy to patent. And it's also counterintuitive, and we'll get another slide that clarifies this a little bit. But as things become more complex, they're easy to patent because less people are thinking about them, and there's less prior art. Prior art is art that's out there, you know, in the public domain. Papers, patents, publications, websites, anything that's published that humans can access is prior art. So as things become very complex, the level of prior art goes to zero. And that's why super complex inventions are very easy to patent. Simple inventions are very hard to patent. So this leads to this next slide, importance of patenting versus level of technology. As technology becomes very, very complex, patenting becomes less important. Why is that? Because reverse engineering becomes very difficult, right? This could become a reverse engineering on another axis. Now you can see that you know, as things become high tech, reverse engineering becomes difficult, which means patenting becomes less important. As things become low tech, patenting becomes very important if there's a business purpose. I keep pointing that out. You know, if you're doing things academically, that's fine, but most people are trying to make money off of their innovations unless they're giving them away, which is also fine. So the example I like to give on this is my first trip to Finland. Okay, I was going to Finland for something called polar bear pitching. Polar bear pitching is Shark Tank from an ice hole. The venture capitalists sit outside the ice hole, and the startups get in the ice hole and they pitch their idea, and they get unlimited time from 1 degree water, 1 degree C. Now, I wanted to go there because I said, what the fuck? I'm like, really? There's actually something like that? So I volunteered to get in the ice hole, not because I was pitching anything, just because my startups were getting in the ice hole. I said, if my startups have to get in an ice hole, I'm going to get in a fucking ice hole. And I did in 2015. And, you know, I'm not sure why I went there, but let me go back to the slide. So, you know, as technology becomes very, very high tech, you know, patenting becomes less important. And as technology becomes very, very low tech, patenting becomes more important. Oh yeah, back to the right. So there I am in Finland, and I'm in Helsinki, and I checked into this hotel, and I noticed that in order to leave the room, in order to turn on the lights in the room, you had to stick your key card into the slot in the room, and that enabled the electricity in the room. It turned on you could turn on your TV, everything. I had never seen that in the United States. I said, wow, this is so freaking cool. And of course, being an engineer, I immediately thought of 1,000 ways to do it. Magnetic, switch, mechanical. Right now, that invention is so simple. As soon as I tell it to you, you can think of 1,000,000 ways to do it. Now, that has business value. For example, if you were a hotel that had patented that concept of having a key fob, one of these cards that enables the electricity in the room, your hotel would actually be using less electricity than the Marriott hotel. And now you could license that innovation to the Marriott hotel and you could make money off that innovation. I believe it was not patented because per the Scandinavian culture being open source, everything is not patented, as I quickly learned. I'm visiting Yamp University of Applied Sciences in Jyväskylä, and I'm touring the engineering lab, right? And I go into their industrial process design group, and there's this Finnish professor there that had created this incredible machine that mimicked industrial processes like manufacturing semiconductors. It had pumps, it had pistons, and it was all computer controlled so the students could program all these processes and learn, for example, how to process various industrial processes. And I looked at the professor, being very naive, my first time in Finland, and I said, "Is that patented?" And he gave me this very sort of strange look. He goes, "No." I go, "Oh, really?" I go, it's a really nice design." He goes, "Yeah, but we sold 2 to MIT." And I said, "Did they ever buy a third one?" Do you guys get what I'm talking about? Why didn't they buy a third one? Well, it wasn't patented. It wasn't patented. They gave, by him selling that one machine, he gave MIT the ability to create 1,000,000 of them and not give them even a thank you. Yes, he did get paid for the 1 or 2 machines. So, there I was in Finland learning very valuable lessons because here I am walking through technology, none of it patented. In Finland, they have these racks for drying dishes that basically they put a rack over the sink. So after you wash your dish, you stick it in the rack and it drips into the sink and dries the dish so you don't have to dry it. Not patented, not in America. Brilliant, brilliant, brilliant invention. High business value, very easy to reverse engineer. And I kept seeing many, many things like this. They had these little shacks, right, at Yamp, where basically you put in wood and out comes wood pellets. They had another shack, you put in wood pellets and out comes electricity. And I looked at him, I said, "Is this patented?" You guessed it, no. I said, "Why don't you put the 2 shacks together so you put in wood and you get electricity on the output?" I have 1,000,000 stories like this of what I consider lost opportunities where people without knowing have just given away their innovation. That same university, and I hate to pick on them, I had a meeting with this inventor, a Finnish inventor, didn't speak any English, that had been in the logging industry for like 50 years, okay? He was an expert at logging. And he showed me a machine that harvests logs and runs off of the sawdust that's generated when you harvest the trees, okay? Now, sawdust engines were developed during World War II, okay? And this guy had a schematic of the whole entire machine, how it cut the wood. It's a sustainable tree harvester, which I always find kind of funny, sustainable tree harvesting. Anyways, he had invented a sustainable tree harvester. And I looked at this invention and I said, "Oh my God, this is incredible. You have to patent it." And I try to work with the university and I said, "Hey, I can help you guys patent it. That's what I do. I can help you." Didn't hear a word. I come back like 2 years later and I'm walking by one of the rooms and there's a picture of what looks like a tree harvester. So I go to the attorney at Yamp and I say, "Hey, is that the tree harvester?" And she goes, "Yeah, and there's a couple of problems that we need you to solve or talk about." I go, "Okay." So I have a meeting now with the researcher that worked with the inventor for the university to, quote, monetize this invention. And I look at him and I go, okay, so what's going on? He goes, we got our finished patent. I go, really? You already got a finished patent? And I looked at it, and he only protected the part that dries the sawdust. You know, it has to dry the sawdust before it gets fed to the engine. And I said, wait, the inventor had the whole entire invention. Why did you only protect that? He's like, because that's the only thing we built right now. And I looked at him, I said, sawdust engines and for World War II. You don't have to invent that. It's already, you know, they didn't have a basic understanding of patent law. They should have protected the entire concept. Next mistake, they got the finished patent, but they didn't file worldwide. Finland is 0.1% of the world market. And now they're talking to International Harvester, a major US corporation that's very interested in this technology. You know what I told them? Stop talking to them immediately. Why? Because it was unprotected in the United States. It's only protected in Finland. And not only that, they only protected the part that dries the sawdust. Major fails, major fails. And you know, what I try to teach startups is, you know, how do you protect your shit from the very beginning? How do you execute a proper plan so that you don't end up making the mistakes that I've seen happen a million times? Patenting versus product shelf life. This is important because this is the apps market. You know, when somebody comes to me with an app and they go, you know, should I patent it? I'm like, what's the shelf life? You know, is it going to be replaced in 5 months? If so, don't patent it. Put it on the Google Play and the Android store and try to make as much money as possible, because somebody's going to copy it and, you know, you're going to be driven out of the market. So as product shelf life goes to infinity, patenting becomes very important. And what that means, you know, gaming is a good example. I've lectured on, you know, intellectual property issues with respect to video gaming, because I'm an avid video gamer, or I used to be. And, you know, let's look at software, for example, a gaming engine. Now, when a software developer that has an engine goes to a gigantic producer like EA or whatever, EA wants everything. They want the engine, they want source code, they want the amp, they want everything, okay? However, that engine could be used for other games. Okay, so in that situation, you know, a well-advised developer would, you know, a patent attorney advising that type of developer would say, look, you want to patent the game engine and you want to license the components that are specific to the game to the manufacturer, so that way you can use the game engine to create other games. So there's an example where the game engine has a long shelf life, but the software itself might not have a long shelf life. So in that situation, you would license the characters and the story and all that kind of stuff to the publisher, but you might want to keep the game engine because it has a longer shelf life. Now, if you're talking about an app on the App Store, you know, that's going to be around for a year, why would you patent it? It costs a lot of money to patent, and it takes a long time to patent. So in that situation, the shelf life is very short, so patenting does not become as important. And of course, I have a story to go with this slide, because most of my slides come from real world stories. I was in Finland on my first trip, and I went to one of their innovation labs called Protomo, which is a incubator, for lack of a better term. And I was giving this lecture there, and I had many startups coming to me, you know, and saying, hey, I need your help. And I had one specific startup come up to me, and they had won the Nokia app competition on something called Dive Code. I forget the exact name of the software, but basically it was a graphical user interface dive computer. Now, I don't know if you guys scuba dive, but when you scuba dive, you have to keep track of your, you know, when you flew, you know, what depth you're going on, how long you're going to be under, and you have these very complicated dive tables, which are based on physiology, you know, how long you can stay underwater at a certain depth before you start getting the bends, that kind of stuff. Very, very complicated. These kids had converted that into a graphical user interface that had a diver, a plane, a boat, and you could literally drag these little icons around and it would turn red when you were violating dive physics and green when you weren't. So they actually solved a very complex, a difficult problem of having used these complex dive computers using a graphical user interface. And they said, yeah, we won the Nokia, app competition. I said, when? 13 months ago. Now, I told you the US has a 12-month grace period. Had I gotten to them 2 months earlier, I could have protected their intellectual property in the United States. The rest of the world is what's called absolute novelty. So as soon as they disclosed their stuff and won this competition, they gave it away to the world. They had 12 months in the United States to get a patent on file. US is about 60% of the world market. So they still could have monetized that considerably. I did buy the app. It's like $3.99 and it's a great app. But see, they were thinking small. When I saw that app, they saw an app for OS or the Play Store. I saw dive computers. I saw US Diver. I saw all the major diving corporations in the United States wanting to use this graphical user interface on their watches, their dive watches. And had they not missed that particular boat, we perhaps would be licensing their technology to major US corporations, which, by the way, are going to be using that 100% free, and they will not send a thank you letter to those Finnish inventors. Provisional versus non-provisional. The US has a concept called provisional patents. And a provisional patent is a patent that puts your mark in the sand. It allows you to establish your priority date for a patent. In patent language, everything is based on priority. What that means is whoever files first gets a date, and everybody else has to beat that date. The examiner has to beat that date, and everybody after them has to beat that date. In other words, if their invention came after that date, they don't have an invention, just like the IBM tech briefs. When IBM puts out that tech brief in 1971, anybody after that comes up with that invention, that's prior art and they can't get an invention on it. So the United States has the concept of provisional patents, which are patents that do not get examined, but they do put your mark in the sand. They establish a priority date. And then within 12 months, you have to decide what to do with it, whether you file it in the US only or whether you try to file it worldwide. So the way I use provisional patents with startups and innovators is to capture a development cycle. Because in the world of absolute novelty, you know what my advice is to you? File early and file often. Now, who does that favor? Well, you're looking at it. I'm telling you, you have to file early and you have to do it a lot. Well, I do that for a living, which means that rule favors me, okay? It doesn't favor you. So my advice to you is file early and file often. Now, how do I make that practical and lean for startups? The way I do it is I teach innovators how to file patent applications so they don't have to use a lot of my time. And then we use the provisional process to capture a development cycle. Because remember, I said, once you file the first provisional, you have 12 months to file a non-provisional, either US or worldwide. So you have a 12-month window to capture your innovation. And I use these provisionals to capture innovation during that 12-month window. So let's say provisional 1 gets filed at T0 on the basic concept that somebody has, okay? Now they've created a mark in the sand. Somebody has to beat that date, okay? Now let's say 6 months later, they solve other problems, which, by the way, always happens. I've never been on an engineering project where from start to finish, nothing changed. And by the way, if you can execute those kind of projects, I will hire you immediately, because something always changes. Problems come up, bugs come up, things have to be fixed, new features get introduced. Well, the provisional gives you a way of capturing a development cycle. And I like to think of it as like an onion, okay? There's the heart of the onion, which is the first provisional that you file, okay? And the layers of the onion are the additional provisionals that you file to capture substantial developments during that 12-month period. So by the end of the 12-month period, you file a US or a worldwide patent application through the PCT that claims benefit to all the previous provisionals. Now, each provisional gets its own date. So if provisional 1 has feature A, it has date 1. If provisional 2 has feature B, it has date 2. If provisional 3 has feature 3, it has date 3. That's because the provisional puts a mark in the sand of when you invented something. In other words, you can't go backwards. You can't say, although I filed on this date, I'm claiming priority to the previous provisional. You can only claim priority to what you disclosed at that point in time. But the provisional structure is a way that I work with startups to capture a full development cycle from alpha all the way to release. Now, 12 months seems like really fast, but let me tell you an example, real world. I was working at Hughes Aircraft, and at the time we were getting into the concept of test equipment that's rack-based. Okay, typically you would buy a logic analyzer, you would buy, a timing module. They each had their own power supply. There were these big bulky units. Somebody came up with a brilliant idea of what's called the common interface bus, which is a rack where you can stick a timing module. You can stick whatever modules, and you can expand the rack based on whatever technology you need in it. Well, I went to Hughes Aircraft and I said, look, this technology is going to be big bucks. We have super fast ADD converters. Why don't we start making some timing modules, some frequency synthesizer modules for this market? And I said, but by the way, we have to have a product in 6 months from start to finish. Now, where did I get that 6 months? It's from the HP Tiger teams. HP has a concept of Tiger teams where they have a flat structure. They have a business guy, they have an engineering guy, they got a program manager, they got inventors. Flat structure. When the inventor says, or the innovator says, I need a logic analyzer, he goes to the manager who goes to the business guy, and that day they make a decision, and the next day the innovator has a logic analyzer. It's a flat structure, it's non-hierarchical, it's a Tiger team. They're able to go from concept to product in 6 months, and they did. Within 6 months, they had boards on the market for this particular technology that had just been developed 6 months earlier. Well, I'm at Hughes Aircraft with 50 layers of management. So for us to get a logic analyzer, it has to go through 50 levels, and you might see it a year later if you're lucky. So we missed the bus. We didn't get into that market, even though we had some of the fastest ADD converters on earth. And it taught me a lesson, that when you work with startups and you work with innovators, you have to be nimble and you have to be fast. And you have to protect your technology from the very beginning, and you have to have a plan. You have to have a plan of what you're going to do with that. Good, now I'm going to cover a little bit of non-patents, good versus bad trademarks. Trademarks, as I said, is branding. Google for search engines, Apple for phones. 20 years ago, if I said, give me your Apple, you'd be like, hey, why are you trying to steal my fruit? Now you think I'm trying to steal your phone. Why is that? Because Apple has spent a lot of money marketing the Apple brand, so that when you think of Apple, you think of computers now. So trademarks is branding. And what's a good brand? A good brand is something that does not suggest the mark. Apple does not suggest computer products. That's why I use it as an example. 20 years ago, if I said, give me your Apple, you think I'm talking about your fruit. Now you think I'm trying to steal your iPhone. So Apple is a good brand because it does not suggest the technology. What's a crappy brand? I was on the freeway driving and I saw wedeliverflowers.com. Great website, shitty brand. Because wedeliverflowers.com suggests what they do. And the more descriptive something is, the harder it is to trademark it. So when you want to trademark something, you want to be innovative, okay? You want to do a Google search. You want to make sure other people aren't using the same name. And I'll use an example for this. I had a client that was developing some pet toys, and he wanted to get pet toys with a Z. And I said, that's pretty descriptive. You're making pet toys and all you've changed is the Z. I bet you can't get the website, and he couldn't. I bet you there's other companies that have that name, and there was. I said, go back and, think a little bit based on this little lesson. And he came back with the trademark Tiny Paw, TINIPAW, and it was a little logo of a foot. I said, that's brilliant. First of all, he was able to get tinypaw.com. There were no trademarks, and we were able to get the trademark very easily. And it's semi-suggestive because Tiny Paw implies pets, but it doesn't really imply the fact that it's toys or whatever, which means with Tiny Paw, you could do pet toys, you could do mugs, you could do all sorts of different products and services. And we've hit an hour already. And should I keep going or should we stop?
No, for sure, keep going. But if possible, we would like to start the Q&A in about 15 to 20 minutes. So I see in your PowerPoint presentation that you shared before that there are a lot of things that you would like to talk to us about. So if you could speed that up a little bit, then the people watching this can also ask questions, and then we'll do that after you finish the presentation. Thank you.
I think I'll just go through the graphs because that's the main points of the lecture. The other stuff is like costs and stuff like that, which is kind of boring actually. So we'll hit the interesting stuff, hopefully. So employer versus employee ownership always comes up. It also comes up in third-party situations where you hire somebody to do software, or we have a Mars project with lots of different people working on different things. Hint, hint. Ownership becomes very important. And the way companies do it is if it's work-related, as things become more work-related, the ownership becomes to the employer, right? And which makes sense. It's fair. If you're doing work for somebody's project and you're getting paid, why should you own the intellectual property to it? Now, as it becomes non-work related, then it becomes more the rights of the employee. Now, in Europe, they've codified this stuff. In the United States, it's all legal action. It depends. In the United States, when you sign a contract with an employer, make sure that you read the section about intellectual property ownership and who gets what and what you get. Employer versus third-party ownership. This was the gaming situation, where you have a developer develops a game engine, if it's, the game engine, you could say is non-contract related because it can be used for many, many contracts. So in that situation, you would want the person that has the gaming engine to have the rights in that ownership. However, as it becomes more contract related, for example, the publisher says, you're going to design this engine for us and we're going to pay for that design. Well, in that situation, the employer should get those rights under a fair model, which is, I always like to think of things in terms of fairness. Now, what is the ultimate problem? Well, you guessed it. IP in space is the most complex problem that exists right now. And that's because you have multi-corporations, multi-individuals, multi-nations, all innovating in a non-jurisdictional environment. I mean, who owns space? It's the ultimate problem. I'm not going to address it here. You guys had a very, very long lecture before on space law. All I can tell you is the contracts will be about a few thousand pages long, which is not nice. And I hate contracts. Okay. So I thought I was done, but I'll hit a couple of more. When to search and when not to search. Searching costs money, and this is actually a function of search costs. Why would you spend $50,000 on a scour the earth search when you can file a patent for $20,000? So, as search costs go to infinity, searching becomes less important because it's just cheaper for you to file a patent and hope it sticks than to spend a bunch of money trying to figure out if there's any needles in the haystack. Also, This is related to when do you recommend searches or not. When somebody's an expert in their field, I'm going to sound like an idiot if I tell them to do a search. Okay. I worked at Hughes Aircraft. We were doing satellite communication systems. We were doing high definition video over satellites. We were the first ones to do that, by the way. I was working as a patent attorney outside for them. These were Chinese PhDs that were developing this technology. They would give me a stack of white papers and they would say, Carlos, this is the best prior art on earth, not patents, white papers. As technology goes to infinity, there is no patents. It's all white papers. It's all academic. They would give me these white papers and say, this is the best prior art, but this is the problems with it. Now, that's because engineers don't reinvent the wheel. In other words, they weren't getting paid by Hughes Aircraft to reinvent the wheel. They were getting paid by Hughes Aircraft to solve very, very complex problems, which maybe only another 10 people on Earth were trying to solve. So in that situation, I would never ask them to do a search because I would look like an idiot. They would give me the best prior art and I wouldn't have to ask them for a search. So as the expertise in the invention goes to zero, then searching becomes more important. For example, when my wife got pregnant, I came up with a kitty litter box design, but I knew there was a million other frustrated husbands coming up with kitty litter box designs. And sure enough, when I searched it, there's millions and millions of kitty litter box cleaning designs. I found one that was close enough to my idea that I decided that I would not go after it. 1 week later, I'm in Petco, and there's my invention, $20. I bought it, patent pending. I missed it by a year. I always tell people if my wife would have gotten pregnant a year earlier, I may be not talking to you guys right now. IP portfolio size versus valuation. This is important because this is the catch-22, as I call it. You need lots of patents to keep the corporations away or to get bought by the corporations, but it takes lots of money to make lots of patents. So as the portfolio size increases, the valuation of the company increases, and the ability to get bought by the Googles or keep the Googles away increases. But the question is, how do you develop a patent portfolio cost effectively? And that's my expertise, is what I call lean IPR. This stuff we're not going to cover because we've already gone, this is some strategies for patenting, which we can cover at another lecture. Usually this lecture is, can stretch on more than an hour, depending how many beers I've had. And we're going to go ahead and stop here. And that is all I have on the lecture.
Thank you so much, Carlos. That's very interesting. And as you said during the presentation, actually these simple graphs, you can keep it open actually. If you could, that would be great. If you could reopen it. Yeah, because I feel that some of the questions regard some of the things that you have talked about and shown on all of these graphs that are actually very handy for people who are novices at patent law and anything legal in that case, particularly in the space domain that Nexus Aurora is active in. So it was especially for me very enlightening. So thanks, first of all, thank you so much for the very clear talk about a very complex subject that not many people can grasp. I'm gonna just keep on asking some of the questions. I'm gonna already also tell all the people watching this on YouTube now live and also on our Discord server, keep sending in your questions so I can add them to the list as well. But for now, I'll start with the question by a space instructor, which you know, of course, yes. And that is the question of how do you split profits on a patent if there are co-authors that have not worked as much as maybe some other person who's also the author of this patent. Can you explain about that, please?
Yeah, that's actually a wonderful question. And the interesting thing about, I told you about this Open Innovation Engine, and we base it around inventorship, okay? And inventorship determines ownership because inventors own the patent. Whoever is named as an inventor on this patent owns it unless they have a contract with Hughes Aircraft to assign it to Hughes Aircraft. So in this situation, even though I was an inventor on a patent, I had a duty to assign it to Hughes Aircraft, which means they became the eventual owners. Now the question arises, what happens if these are independent inventors, which typically happens in an open collaboration environment? Well, the way we've decided to handle this is based on inventorship. So for example, under the OU812 model, if you're a co-inventor with somebody, the split is 50-50. If there's 3 inventors, it's 1/3, 1/3, 1/3. Now you could get more complex and get into the ego of, yeah, but my feature is more important than your feature. We decided that that would be too complex and would create too much drama. So the way we've decided to do it is that whoever is named as the inventor on the patent, which is a legal requirement, by the way, inventorship is based on claims, and claims are based on features that end up in the patent, and whoever developed those features has to be named as an inventor. So in the Open Innovation Engine, we have solved this problem by saying if there's 3 inventors, it's a 1/3 split. If there's 2 inventors, it's a half split. If it's a 1 inventor, they get it all. So does that answer your question?
Yeah, it's not my question, to be clear. I'm just relaying these questions to you. I'm going to ask a space instructor in this case if it answered this question, because this is one way to work with this, because here you say you split it evenly in your suggestions. But the question was also, of course, about let's say you don't want to do that. Let's say you have co-inventors for this patent, but let's say I want 80% and I want to give you 20% of the profits of this patent. Is this actually very complex, or is it actually as simple as I suggest right here?
Well, actually, you raise a good point, is that before you get into anything like that, you should have a contract that clearly specifies what everybody expects. Because otherwise you're going to have problems. If you get with a bunch of people and file a patent, and this is a real world scenario, by the way, because I filed a provisional with 12 inventors, right? And now it's time to go after the non-provisional, and nobody wants to pitch in, and it costs money to generate these patents. And it's unfair to me to spend my time and my money. I've footed the whole entire bill, right, in order for their benefit. So in this situation, I'm filing a patent with only subject matter directed to myself and to the other co-inventor that wants to be part of this. And the other 10 inventors are just not part of it. They can pursue it on their own if they want, but I'm not going to foot their bill without them putting in some sort of effort. So the situation you're talking about is very easily handled by communication up front. What are the expectations? Is the one guy thinking that he's 80%? Is that the case? Do the other people agree? I prefer to go towards fairness. My model is, look, I don't care whether I think I'm 80% or 90%. I just want to split it evenly because it's simple, it's fair, and it creates less hassle. But anything that you want could be done in a contract. Anything. That's what contracts are for. And based on that contract, you can execute an assignment that now legalizes that contract with whatever terms you agree to.
Which could, in fact, mean that within this patent, you do not specify these percentages, but in a separate contract that
Yes.
you have together, you could say the split is going to be 80-20, for example, or even split it with. Oh, you can't. Okay, can you explain that a little bit more then?
Yeah. A patent gets filed with inventorship. All those other negotiations are external and they have to be done beforehand. So it's wise that before you enter into something that could be patentable, that everybody is clear what they're going to contribute, what percentages they expect, so that as soon as the patent gets executed, that contract gets executed, and everybody signs it, and everybody signs to what they agreed to, and that gets recorded, so that down the road somebody can't whine and say, "Well, my 20% should be 30." No, this is what you agreed to. This is what we did. This was fair at the time. You can't later on go back in time and say this is unfair. By the way, the reason we're capturing everything in blockchain and smart contracts and keeping everything open is for that exact reason, so that the whole entire world will know this was the agreement, so that, 9 months later, when the thing is worth $5 trillion, you don't have one inventor going, yeah, but my thing was more important. I should get more of that.
Yes, that's a very important point you make. And I think it's also very interesting for all the people in the Nexus Aurora Global Aerospace Innovation Network, because we have so many people and so many projects who are working on many different aspects of space exploration. And let's say people are working on a new spacesuit as one of those projects. So when do you start patenting? And I feel like those kinds of projects can really learn a lot from this talk. So I already feel that this is very interesting, and we really hope that you would be interested in staying a part of Nexus Aurora, and sometimes maybe giving some of these projects some advice, as you have been doing for this wide audience right now. I'm going to go to the next question, and that's actually on Reddit, on the Colonize Mars subreddit, and it is from Nicolas Marsala. And the question is, in order to become a patent attorney, what kind of education does a person require?
Okay, that's a great question, and it depends on where you're residing. In Europe, they typically separate lawyers from engineers. So in Europe, they have something called patent agents, and they have to take a patent bar like the European patent bar. And then there's patent lawyers. Now, typically, they keep the lawyers separate from the engineers. Some engineers actually end up also going to law school to become the equivalent of a patent attorney in the United States. In the US, it's required that you have a technical degree and a law degree. In Europe, you can be separate. And this gives me a big advantage when I deal with when I compete with European law firms, because I'm an engineer and a lawyer. And that means I can talk to engineers directly and I can file directly, versus in other situations, the patent agent has to talk to the patent lawyer, then the patent lawyer does the filing. And what that does is it drives costs up very, very high. And in fact, Europe has some of the highest prosecution costs perhaps on Earth.
But the interesting thing as well, as you talked about, is that speed is of the essence, sometimes because of the 12-month grace period, for example. And since you and maybe other people as well can do both, the engineering part and the patenting that is needed, you can actually speed up the process in general. That's good to understand. So another question from Mr. or Mrs. Paralun on the subreddit of Colonize Mars is, first a compliment. Nice that you are helping the little guys, the small entities. It is much easier and often more profitable to work with large entities, as you also talked about in your presentation, of course. So now that we know that you are the rare patent attorney that trademarks what they do, perhaps you could share something patent law-wise that might impact Mars colonization. And also, maybe you understand what is meant here, but also, is there a specific art unit where these patents tend to fall into?
Good question. I do not know which specific art unit, but I could definitely figure it out. I licensed some software recently that's very, very expensive. It's like $13,000 per year, that allows you to do searches and create what's called patent landscapes. And a patent landscape shows valleys and hills. Hills are where all the patents are, and valleys are where all the patents aren't. So for example, I could search on any topic that you want, and I could generate a list of patents and a landscape for that patent. And I could see exactly which players are playing in which fields, where the patents are, where the patents aren't. And okay, so that was the first question, whether I know which class. Not offhand, I could. And the first question, I've already forgotten. I'm sorry. Specifically about Mars colonization, if you could share about what you would advise maybe for all of these guys in the different Discord servers that are attached to Nexus Aurora, maybe also. That's actually the one that addresses that, is the patenting versus product shelf life. I've been watching the Netflix Mars series. I've binged the whole entire thing, and very, very interesting. But patents have been limited to 20 years. So the question, this graph answers that, right? If you're developing stuff that's not going to be monetized in 20 years, well, patenting is probably not that important.
So that's actually, you could read this graph the other way around as well, right? Because depending on when the product shelf life starts, that's also an interesting thing, of course, because here you say there's, you talked about an app, for example. If it's like 5 months and then, don't patent it. But in this case, the other extreme is actually the case. And that is the fact that it will take maybe 20 years before this invention starts to become interesting. And that's the other problematic thing.
Well, that's not problematic, because as it turns out, innovative patents have more value at the end of their life than they do at the beginning of their life. And why is that? Well, because it takes a long time for people to catch up with innovative stuff, right? There's a story that if I can share about this guy named Lemelson. He changed the patent laws single-handedly. He was an inventor from the 1950s that was patenting things that wouldn't occur for another 100 years. Now, the old patent law was 17 years from the date that the patent issued, not the date that it was filed. So he was filing stuff in the 50s that wouldn't occur until the 70s. And for example, I examined one of his patent applications. It was the concept of having a laser on top of a saw so that the laser would heat up the plastic before the saw blade hit it. So the plastic was softer and would cut easier with the saw. Now, at the time he filed the original patent application, lasers took up an entire room. So how did he get a patent on a laser mounted on top of a saw? Well, he was thinking like an inventor, not like an engineer. An engineer wants to touch it, feel it, and hold it right now. Something in the future has no value to me as an engineer. I want to hold it, touch it, and feel it right now as an engineer. An inventor, however, says, what technology is available to me right now and 20 years from now? That's the window.
Exactly. So the question is, if this invention, for example, if you would do this at this moment, and some of the inventions, I think, within Nexus Aurora and all the projects might actually only, start being produced and have any real value maybe in 30 years, for example. So what would you advise then, looking at this graph? Would that be a separate graph? Or as you said at the beginning, you have 3 options. You can patent to monetize it, but that's for 20 years. You can publish, but then you cannot patent it anymore, or you can keep it a secret. So now the question is, do I keep it a secret for 20 years until it can be monetized?
In your situation, since you guys are open innovation, the way I would look at it is publish. If you know that it's not going to be doable in less than 20 years, then why spend the money patenting it, right? You're gonna get a patent and then it's gonna have no value because it's gonna expire before people are actually using it. Patents have no value unless people are using them. And this is why innovative patents have more value at the end of the lifetime, because that's how long it takes for people to catch up. Simple inventions, people catch up immediately. And that's why I had that other graph. If something simple and has a high business value, you patent it immediately because you can get the monetization immediately. As you start going up the level of technology, now patenting becomes less important, especially when you look at product shelf life or reverse engineering or keeping something secret. Now, in an open innovation community, I don't know how you would want to keep something secret because that goes against the concept of open innovation. So in this situation, I would recommend looking at some of these things. I covered the IP review committee. and to make a decision, that's based on research. Do you think this is going to be monetizable within 20 years? Well, if the answer is no, well, patents are out, right? And that only leaves publish and keep secret. Can you keep it secret? Do you want to keep it secret? Yes or no? I should make a flow chart for that, actually.
Yeah, well, that would be actually great to share with all the teams, because it's actually quite logical, and in that case, good for a flow chart. It's very clear, at least from your talk. Thank you so much. I'm going to go to the next question by James Isaac.
Maybe I ask.
As someone who would like to get into aerospace engineering at age 30 with no relevant experience or education, would you recommend a military career, an apprenticeship, or just go for a degree?
I'm biased because I'm ex-military. And I will tell you, but for the military, I would not be talking to you right now. The military gave me the mindset. I'm going to share a story which is embarrassing. I graduated high school with straight D's, okay, intentionally. I was taking calculus and physics and chemistry, but I intentionally engineered D's because I did not believe in education, and my goal was to get out of high school and become a multimillionaire. Now, I got out of high school and I realized
that part worked.
I realized that may not have been the best plan of attack. And by the way, I wouldn't change anything in my life because, everything that's happened to me is the reason I'm talking to you right now. So at 17, I joined the military to get out of the house, basically. And the military gave me the mindset that I have now. And it's very simple. And I'm going to share this with you because I think it's important. I talked to you about being at this R&D lab with guys from Caltech, MIT, and Stanford and feeling like I'm not good enough. Well, you're always good enough, okay? If you look at if everything's a bell curve, and it's a beautiful curve, a statistical distribution, beauty, athleticism, intelligence, every single human characteristic makes this wonderful curve where most of the people are in the middle. There's some super beautiful people and some super ugly people. There's super smart people, super dumb people, but they're actually the end of the curve. They're the skirt of the curve. Most of us are in the middle of the curve. And I've always said after the military, this is my philosophy. If I can do anything that's humanly possible based on my physical ability or mental ability, it can be done. And I know there's millions of people that are less capable than me that have done things much greater than me, like become brain surgeons or rockets. So I know that if I set my mind to anything, I want to get a PhD in physics, okay? I have a master's in electrical engineering. It means I would have to go back and learn math all over again because, as you know, theoretical physics is a lot of math. And by the way, I would go into theoretical physics for a specific strategic reason. My stepdad, who was an engineer for 40 years, he designed missiles and satellites. He's got satellites that are still in space right now that he designed when he was a young man. He was my guiding light. And he told me, he goes, as an engineer, you will always have a job, and don't ever let anybody tell you that you can't do something because of your education or upbringing. He was the one that let me go into that lab of prima donnas of Caltech, MIT. But for him, I would have gone, oh my God, they're smarter than me, And the point being is that, you can do whatever the hell you want. And if you're on that bell curve, there's a million people dumber than you that have swam the English Channel or with less, anything you can imagine as a human. If you're in that bell curve, there's somebody else that's better or worse. And what does that mean? You just have to do it, right?
I feel actually that's a great description of maybe the whole American life philosophy as we maybe get to see it from Europe. I'm from Europe, so that's a nice way of sharing this with us.
So military is my recommendation. If he can qualify with VAP or whatever test he has to take to get in, you can get basically hands-on experience as a computer scientist, which when you get out, whatever you want to be, whether it's computers or whatever. When you get out, you have more experience than anybody that's been in industry. In other words, combat paramedics, when they get out, they become paramedics. They become doctors because they've already had, much more
practical experience. Yeah.
So I would recommend the military route, but no disrespect in any way. Respecting.
No.
Where you go.
You were asked for your opinion, and this is not in any way disrespectful. At least I feel this way. It's a clear answer. Thank you. Another question is about something that I think Elon Musk said, that with SpaceX, he's not actually doing that many patents because his main competitors are other governments, and they don't really seem to take really light notice of all of these patents that even other countries are setting up. And we see some very similar rockets emerging in China, for example, compared to some SpaceX rockets. So what would your response be to this kind of thinking? Would you say, yeah, that's true, don't patent something that only other governments can do? Or would it be worthwhile doing that in a worldwide patent application?
Well, first of all, if I had the money that he had, I would do whatever the fuck I want. So, the fact that he's doing whatever the hell he wants, I applaud him for that. Now, speaking of Elon Musk, as you know, a while ago, he opened up all his patents for
Tesla, I think, right?
For Tesla. Yeah. Now, the interesting thing is,
not completely actually, because I read about it. Oh, you're going to talk about it. Yeah.
I'm going to talk about that. It seemed like a grand gesture, right? But if you read the fine print, as long as you're not competing with him. So basically, he did protected open source. He said, it's okay. It's free for personal educational use. Everybody else pays. Now, I know why he did that. I mean, why would he give his technology to his competitors? Now, that's not a smart business decision. Now, as far as whether he's filing patents or not on the stuff he's doing or not, I suspect that it's probably based on whether he thinks anybody's going to be copying it. If you're the leader in something, this is something that's interesting. If you can establish market value very, very quickly, the example I give is Angry Birds. Okay, there's a million knockoffs of the idea, but Angry Birds is still Angry Birds, and they still made freaking mega millions off of it. And they're still making mega millions off of it because they got the brand and they built the brand and they built the market before anybody else could. Now, he has that kind of money where he doesn't have to care about patents. Google doesn't have to care about patents. The only reason they care is because we have a patent system. Without a patent system, they have no shits to give because they have infinite money. They can R&D, they can develop, they can buy up startups, they can, so
in a sense, you could also say that they have, as you said at the beginning of your talk, influenced government into making it way more a better situation for them because they have this much money. So in that case, because there's a patent system, they don't only care about it, they influence it very clearly towards their own goals, which maybe any company would do because they are of course incentivized to stay alive themselves, and this is one way to make sure not too much competition arises. But it is, in fact, as you said in your talk, maybe problematic because the new guys will have a harder time winning from Google and other large companies. Okay, so one thing that's maybe interesting. Tell me.
I'm sorry. Keep going, but I want to remind me of an example that I want to give about related to health-related applications.
Yeah, go ahead. It's fine.
So I go to this thing called Slush. It's in Helsinki. It's called Slush because they have it in November. And if you've ever been in Helsinki in November, it sucks. It's like snowy rain. It's dark. It's cold. It's like the worst possible environment to have a startup conference. And they have it. And there I was at Slush as a patent attorney. I'm the shark swimming amongst the minnows, because, I'm a friendly shark. I tell people I'm a good shark. There's a lot of bad sharks, but I happen to be a good shark. And here I am swimming amongst the minnows, and I see 12 companies, startups, doing health-related apps and sensors and devices. And I go to each one of them and I go, have you patented? No, 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 no. They're too expensive. They can attack us before, during, and after. You know the drill. And in that situation, who has the negotiating power? Is it the 12 individuals or is it the mega corporation that has all the money? Well, that's a rhetorical question. They can sit there and pick and choose who they want to, you know, who has the best brain power, who has the best product. And by the way, you're going to get as little as possible because they want to maximize profit, right? In other words, the best case scenario for corporation is you come in as an intern, right? We don't pay you anything, but you get very, very good experience. That's the best case scenario under an extreme capitalist system. So I looked at this and I'm like, you know, if these 12 companies actually, instead of competing with each other, which is the way we've been trained, you know, we've been trained like, oh, I'm going to be the next Google. Guess what? You're not. Okay, I'm really, you know, I hate to break this to you, but you're not going to be the next Google, because I've worked with thousands of startups and like 1 out of 1,000 make it. Okay, so no, you're not going to be the next Google. And the fact that you're sitting here like this, trying to keep your stuff secret, competing against somebody else that has no money, keeping their stuff secret, while all the people with the money just have full power, is idiocracy. If those 12 companies had actually formed a group, okay, and combined all their intellectual property, the end product would be better than the individual products. And this is the truth. You know, when you combine
this advice would actually maybe be working very well for Nexus Aurora as a whole as well. If you say it like this, it's interesting advice. Before I forget to ask you, I know that you also work on the Open Innovation Engine. Could you maybe explain to the people watching what you do at this in a few minutes?
Okay. Yeah, well, the Open Innovation Engine actually came from the America Invents Act. The America Invents Act is when we harmonized with Europe, when we went to first to file, you can get attacked before, during, and after. When I finally realized what the kids in Finland were telling me was the truth, when they told me we don't file patents, they're too expensive, we can get attacked before, during, and after. And I was like, yeah, but in America we get patents and we, you know, you heard that spiel. So enter the America Invents Act. All of a sudden we harmonize with Europe. We can get attacked before, during, and after. And patent costs go through the roof. And there I was giving a lecture in front of the IEEE on the America Invents Act. And I just about cried on stage. I said, look, I've been helping the little people, startups, small inventors, and universities that need the patent system to be able to become a Google. And now the corporations have changed the laws to harmonize with Europe and to make it virtually impossible for little people to actually ever make it. And it's the truth. You know, and I said, you know, before I used to tell startups they have a 1 in 1,000 chance. Now it's 1 in 10,000. And you know what that chance is? The patent system. That's their only chance. Marketing, they're screwed. I gave you the example earlier. You know, City of San Francisco put out bids for wireless internet in the city of San Francisco. 12 companies applied. Google said free. Who do you think got the contract? You know, how do you compete in open source with corporations that have unlimited money? I'm telling you guys, and I know there's a lot of anti-patent people on this talk, patents are your only chance in hell, and it's still a snowball's chance in hell.
That's a little bit maybe a negative way to put it, but I understand what you mean. And at least it's better to get a realistic idea about this than be disappointed when stuff goes sour. So before, let me just go to the next question, because otherwise we stay maybe too long on this topic. But Mr. or Mrs. Slippery Skeet on the engineering subreddit asks what happens if one individual writes a paper in a journal about a new technology and then another one tries to patent it without changing much from the original paper. And what is also interesting is that so also where's the limit of something being publicly publicized? Because, for example, just as one example, we have many Discord servers which are freely accessible, but not searchable by anyone unless you're a member of the Discord server. Is that already publicizing it or not? So that's so where's this limit? I would also add to this question.
That's a great question, and basically, the way I would look at it as a patent attorney is based on obviousness. Okay, obviousness is like when I disclose a car with 4 wheels, right, with a internal combustion engine. Would it be obvious to swap out the engine for a steam engine? And I would argue that it would be. If you're not claiming the engine, if you're just claiming a frame, 4 wheels, an engine that drives the wheels, whether it's internal combustion, sawdust, or steam, doesn't really matter. So in that situation, if that person putting out the second paper or whatever tries to get a patent, I would make sure to get the first paper in front of the lawyers that are handling that invention, because lawyers have a duty to disclose prior art, right? If I'm filing a patent application and somebody from Nexus Aurora says, hey, here's a paper that you should consider, and I don't consider it and it's relevant, I have committed fraud on the patent office. And, I have no interest in getting patents that aren't patentable. It took me a long time to grasp the concept that I'd have a client with an invention and the examiner would have really good prior art. And I'd be like, oh my God, what do I do? He's got good prior art. I can't get him a patent. And then I had a partner tell me something that's very important. We only get patents that people deserve. If I can't convince myself that it's patentable, how am I going to convince a patent examiner that it's patentable? So for me, I want the examiner to get the best prior art. I want me to do the best job so that way when that patent gets excruciated, which it will during litigation, I want to make sure I have something that somebody can hang their hat on. So in the situation that you're talking about, you're talking about egos. I wrote my master's thesis was, backpropagation neural networks for diagnostic rhyme test word recognition, speaker independent diagnostic rhyme test word recognition. Basically, neural networks for speech recognition that's dependent on the speaker's voice, not speaker independent. At the time, by the way, speaker independent was the holy grail, and I was not quite there. And when I filed my thesis, my thesis instructor, PhD, he wrote himself as the first author. Now, he did not write any of that. That was 100% of my work was what he put himself as the author, but that's standard in academia that your thesis advisor becomes the first author. Well, it's publish or perish, right? I mean, I didn't need the publication, he needed it. And in fact, the first time we submitted it, it was denied. And then 5 years later, I Googled my name and I searched it. And sure enough, it got admitted 6 years later with him as the first author because he kept submitting it, right? Because he needs that publication. So in that situation, a lot of times it's more of an ego thing, I invented this and he's taking credit for it. But the bottom line is prior art is prior art. If you have a paper that's relevant to somebody's patent, and they're pissing you off, well, you have some ammunition. I would recommend that you forward that paper to the company. You find out who the patent attorney that's handling that prosecution is, and you also forward them that paper. And that will make sure that patent gets granted if it deserves to be granted.
Of course, yeah, that's always the case. We have another question by Travis. He asks, who would you contact to begin the process of selling IP to another company?
Okay, that's a wonderful question because that goes to the graph that I don't have, which is an iceberg. And as you know, most of the iceberg is underwater. I'm sure you guys can calculate the percentage. It's based on Boyle's law. Anyways, the very tip of the iceberg is showing, right? And most of it is actually underwater because of the weight, the ice to water viscosity ratio. So I have a graph that shows an iceberg, And on the very tip of the iceberg, I put patents. And on the bottom, I put business and marketing. I've seen many, many beautiful inventions that have never seen the light of day, not because they shouldn't be there, just because the business and marketing was missing. And how that is related to the question has already slipped my mind.
Stop with the beers for the next 15 minutes. No, but it was about selling IP to another company, and this question comes from Travis because actually he put another comment in as well about the fact that he has patented a machine gun design and many prototypes, and his actual question was who he should contact to begin the process of selling IP to another company.
Well, of course you want to contact me because I'm a shark swimming amongst the minnows. And I have a tool called PatSnap, which I can enter his patent and it will give a valuation of the patent. And that valuation is based on metrics like industry and value and use and citations. There's a lot of variables that determine the valuation of a patent. And the software also identifies all the important people in that space, AKA potential buyers. And the idea is to create a marketing pitch that explain, I get back to marketing, right? You want to find a good marketing person that can generate a deck that paints the innovation in its best possible form so that now you can forward this innovation to these parties that are interested. And then typically what we do is we have an auction. I found that patent auctions are the most efficient way to maximize value of portfolios. Right now, there's about 31 companies that are selling and buying patents. I can after this, if you guys remind me, I can generate some links on patent brokering. I think there's about 31 companies. But the bottom line is you want to create some marketing materials and get it in front of the people that are interested in it, the people that are using it. A patent has no value without use, right? So if nobody's citing to it, nobody's using it, well, guess what? It probably has very little value. But if people are citing to it, people are using it, it has a valuation, and you have some targets, now you can contact them and see if they're interested in purchasing the patent. And an auction is the best way I've found to generate the most value at a given point in time. Basically, you get a bunch of infringers and a patent troll all in the same group, and you get them bidding on it. You start the bidding at 0, and at day 30, whoever has bid the most wins. And typically it is the patent troll that wins from real life experience.
And it could even be that you could share profits in the future, maybe, or is it like a all or nothing thing? You have to give it away completely.
Everything in between, a patent.
Yeah, that's interesting. Then, for example, you can say you can get half the revenue of the future.
Yes.
And that would help you in the short term as an inventor, because this will be worth a lot in the future, and it might just be worth, for example, just $1 million now. Yeah. But in the future, it will be worth $1 billion, but you need the money now, so you can use one of those systems also to accelerate the use of this patent in the first place. Is that correct?
That is correct. In real world story, I'm playing Counter-Strike 4 hours a day during law school. That's why my grades were not so great at law school, but I was very good at Counter-Strike. And I get a call from a potential client. He says, my son is playing this game called Counter-Strike, literally as I'm playing Counter-Strike at work. And I go, okay. And he goes, yeah, and he invented the software that prevents cheating. And I knew the cheating that was happening on these servers, very familiar with it. I go, okay, I know a little bit about that. And I get a hold of this kid. He's a 16-year-old kid that invented something called Counter-Strike Guard. It was a client server module that he put out for free on the internet that basically, after people were caught hacking, it created a list, and he aggregated all the lists on a central server and sent it back to all the game servers. So once you got caught on one server, you were banned on every server running his software. And guess what? Every server started running his software. Well, anyways, a major software company decided to copy his idea and release it as part of their software release. And as I'm working at this patent firm, I've got this client, this little client, I got him his patent, and I get some patent trolls were interviewing us. Patent trolls, by the way, they buy low and they sue high. That's their business model. Buy low, sue high. So if they can get the patent for free, beautiful, they sue for a lot of money. And they were interviewing us because we were doing prosecution, and they're going through all my patents and they're giving me crap like, why'd you do this? Why'd you do that? Which in hindsight, I can tear apart anybody's patent, And then they got to this one patent and they go, and we find this one very, very interesting. Is it for sale? It was the cheat prevention system. So I contacted the kid. He was at Stanford by that point, full ride. And I said, hey, if I were you, I would keep the patent and license it. And instead he sold it for 150 grand. Now he only paid 10 grand to get the patent. So, 150 grand on 10 grand is not a bad payday. His dad was pretty rich. He didn't really need the money, but it got eventually it got bought by this patent troll that now has developed it into about 8 or 9 or 10 patents. And see, the patent trolls know how to monetize patent portfolios. They don't do it for ethical means because they don't produce anything. All they do is buy patents, develop the portfolio, and sue corporations or companies. But they had figured out the model that actually is my model, which is how do you get bought by Google and how do you keep Google away? It's the same exact scenario. You develop a patent portfolio. If you have a patent portfolio, it's cheaper for Google to buy you than to steal you. If you want to keep Google away, it's cheaper for Google to go away than to fight you. It's the same exact problem, but how do you develop a portfolio cost effectively? And that's what I solve by teaching innovators what I know. Sorry for the long-winded.
No, that's great. That's great. And in this particular example, one of those intermediary options would maybe have been better in the long run for this Stanford student. He might have gotten, let's say, $100,000 and then maybe 50% of the rights of the future earnings, for example. So that's interesting also for, I feel, some of the projects in Nexus Aurora and all the other people who are interested in space exploration as we are, who are listening to this talk right now. We're busy for a long time. We're going to keep going if that's okay with you, because it's such an interesting conversation. But I'm just also going to remind people, keep asking your questions beneath the YouTube video or in our Discord server, and I'll try to ask them to Carlos. And one of those
I'm here.
Yeah,
I'm here as long as you want me. So
okay, we're gonna keep on going for 3 more hours. No.
Hey,
we're gonna end fairly soon, but we'll keep.
Not a problem.
We're gonna keep asking you some questions, and one of those was from Some Today. That's the name of this person.
Yeah.
Would there be any patenting alternatives similar to in spirit into Libre software licenses or Creative Commons, and would they be better for an open, innovating community?
Well, unfortunately, that's the difference between copyrights and patents. All the open source licenses that I've seen are based on copyright, which protects copying. Patents are more powerful because they protect functionality. In other words, if I can write a claim that says, you have a device that does this, this, and that, I don't care whether it's programmed or which type of device, as long as they do those steps with those components, they're infringing the patent. In a copyright, if somebody develops something independently, it's not a copyright violation. So copyrights are helpful. In other words, if you go back to the umbrella, I like to teach clients to do everything. They copyright their software. They keep things that are secret. They patent things that need to be patented, and they license stuff to make money. That's part of the umbrella. So my answer to that would be is that those type of licenses are very, very limited when it comes to capturing actual utility. That's the purpose of the patent system. Copyright system is to stop copiers. That's why it's called copyright.
I got a very interesting, maybe philosophical question from Marsden Wright, and that is that the World Economic Forum has been talking about this idea of the Great Reset, and in order after the COVID-19 pandemic to rebuild economic sustainable practices, you might think about not using any patents in the future at all. Have you ever thought about any possibility of not using or requiring any patents, and what kind of society would that be? And would that be actually a good thing, maybe? Because it also sometimes stifles innovation, even though you clearly stated that there are a lot of advantages as well.
Well, you have to look at the reason why patent systems are created, okay? Patent systems were initially created for another way of kingdoms to generate revenue. Okay, they had taxation, and now they had another way of generating revenue is through innovation, right? By giving grants, these patent grants. But the actual concept of patent system, which I think is something that shouldn't go away, is the concept of giving the little people an advantage so they can become big people. See, without a patent system in a purely open source world, who wins? Well, the people with the most money will win most of the time. That's been my experience, because if you have more money, you have more marketing, you can sell things cheaper than everybody else, and you can drive everybody out of the market. That is not a world that I want, okay? So whether the patent system goes away the way it is, as part of a formal system, I think the concept of giving people credit for their innovation cannot go away. And the concept of allowing people to monetize their brains cannot go away. And, I work with a lot of libertarians, which we talked about earlier, and a lot of open source people. And one thing that I have to say is, anytime your ideology becomes a religion, please don't talk to me, because you've closed your mind. You've come to the conclusion that this is the only way and there's no other way. And that's not the fact of the matter. Right now we're creating this open innovation engine based on blockchain, and we're using the current patenting system because it's a functional system that allows people to protect their rights and to monetize their rights. However, if we could go to a pure open innovation system with no patent system, where we're basically monetizing those rights without the need for that system, that's the best case scenario. But still, the underlying premise is that I want to have a world that has sustainable innovation. People keep asking me why I'm doing OU812, and I keep telling people it's for my children's children's children. I don't want a world where 4 corporations control the entire world. Why is that? Corporations can only employ about 10% of the population. What happens to the other 90%? Universal basic income, starvation, third world living? Is that the kind of world that we really want? However, I see a world of sustainable innovation where people can actually protect their innovations and monetize their minds. And I will give you the best case scenario of OU812. There's an inventor in India that's the next Einstein. And I will guarantee you there's 1 million of them in India right now that are the next Einsteins. And they have no money. They have no access to the patent system. In that situation, OU812 would form a nonprofit with the goal of the nonprofit of harvesting the innovation of that individual and giving him 100% of the profit, so that now he can feed his village, so that now he can create a startup. This is sustainable innovation. If you allow people from all over the world to monetize their brains, see, the thing is that people only think in terms of lawyers and engineers. There's more than lawyers and engineers. There's DJs, there's artists, there's yoga therapy. There's people that contribute in ways that are more than just engineering and law. Marketing, for example, is a huge area. I want a world where people do what they want because they're passionate about it. I want a world where an inventor in India has access to the patent system. And now that's one end of the spectrum of OU812, 100% pro bono to help an inventor in India feed his village. what's the other extreme? We're harvesting brains. And by the way, people ask me how we're scaling it. We're not scaling it. See, because this engine is not an everybody can join engine. It's a people that I want to work with engine. It's people that share the same mentality of having an open innovation world with sustainable technology for our children's children's children. And the other extreme of it is we've got experts in mycology, growing weed, mycomaterials. I'm an expert in crypto and machine learning. We've attracted a few good brains. And the interesting thing is that you only need a few good brains to generate thousands of patents once they know how to write these patents. And our idea is we're going to go after areas that are highly coveted by the corporations, and we're going to generate there, and we're going to use that to create product startups and services, or to sell the patent portfolios if that's what the innovators choose. Because our model is innovator centric. If an innovator says, I want to sell my patent because I need to feed my family, I'm not going to be, no, you can't feed your family. You have to create a startup because that'll make more money for us. No, if he wants to sell it, he sells it. And we help him do that. If he wants to create a startup, we create a startup and we help him do that. Now, the way the engine works, 10% of all monetization goes back to the engine. That monetization is going to be used to launch product startups and services. And, right now we have Facebook groups that are closed. They all start with OU812 and they end with team. Top team is the main team. It's sort of a recruiting point for projects. And a project starts with me meeting with an innovator and getting a patent application filed. Because remember, my goal is to help the innovator, not myself. So first thing we do is we protect that innovation. Once we protect it, we open it to everybody. And then we try to monetize it by bringing in money people or whatever to help, do whatever the innovator wants, to sell the patent, to create product startups and services. But there's experts that specialize in all these areas. I have experts at licensing that sell patent portfolios. That's not me. I'm an expert at getting the patents. That's my expertise. But the idea is to build a community of people that are like-minded, that want to develop sustainable technology and that work together, where the team is more important than the individual. As you guys know, you may not know, I was going to be Special Forces. And one thing they drill in you in the Special Forces is teamwork. The reason 4 SEALs can take on 2,000 Somalis is because the 4 SEALs are a coherent team that care more about each other than themselves. And you have 2,000 individuals that only care about themselves. That's the only reason 4 guys can take on 1,000 or whatever. What I'm trying to do with OU812 is that same model. And by the way, that's the secret sauce. We're looking for not only smart people, but people that want to be part of the community and want to share this vision and want to be part of something that I think is going to be very big.
I could actually say that this is a really great way to end this talk for now, because this is a great analogy also for Nexus Aurora, where a lot of people are working together on something that is way bigger than themselves, actually. So instead of asking you any more questions, because we will have some extra discussion on our Discord server, so please stay online.
Okay.
After we finish this YouTube live stream. So I would like to publicly in this YouTube live stream like to thank you, Carlos, very much for your generous time and sharing of knowledge. It was really valuable, and we will for sure refer to all of these things that you have taught us to other people who have any questions about some legal issues, patenting, and all of the things in between. So as I said, we will continue this conversation on our Discord server, and I would like to tell everyone watching this on YouTube or otherwise that there's a link below the YouTube video that you are watching right now to our Discord server that is free to join for anyone who thinks this is worthwhile or advancing space exploration is worthwhile. Be part of our team, I would say. Also, do not forget to subscribe to our YouTube channel itself and check out our subreddit for Nexus Aurora. I would also like to say that we have these Saturday space streams each Saturday at 4 p.m. UTC, so make sure you tune in next week as well. I have been your host, Cohen, of the Next Astro YouTube channel.